Hello and good morning, and thank you all for being able to join us for today's webinar, Before the Termination, Unemployment Insurance Considerations and Things That You Should Consider Before Terminating an Employee. We have a great webinar scheduled for today. When we hosted this last week, we actually ran out of time for hosting this, so we will try to answer questions at the very end. There's a lot of great material, but we'll also try to keep up the pace and try to make it very quick. Before we start today's webinar, there are a couple of housekeeping items I would like to go over for everyone. The first off, today's webinar is worth 1 hour of HRCI training credit. In order to receive this training credit, you need to stay with us for at least 80% of the webinar. And also, this morning when you signed into the room, you must have used your full name. We use this name to be able to verify your attendance and also match it against your initial registration. If you're not sure if you didn't use your full name or if you only entered in your full first name, please type that into the chat log now, and that way we can count your registration and also be able to verify your attendance for today's webinar. We will be sending out the HRCI training credit along with a copy of today's slides at the end of the day today, and we thank everyone for being able to do that. You can also download today's presentation. Just above the chat log on the right-hand side, you'll notice a files box. Go ahead and click today's file, the 7.2 Before the Termination. Hit download files, and what that's going to do is open up a new tab in your internet browser, or it's going to open up your internet browser. We can download today's presentation directly. If this doesn't work, please feel free to type that into the chat log, and we'll see if we can find an alternate link for you to be able to download the presentation as well. Unfortunately, we do have to keep everyone on mute for today's presentation. Unfortunately, with just this many people, it's the way it has to be. But if you have any questions about whether it's a problem with the audio, or if it's a problem with being able to see the presentation, or if it's a question about the material we're covering, again, please type that into the chat log. We'll try to answer everyone's questions at the end of the presentation, or we'll have a helpline consultant follow up with you at the end of the day today. And with that, I think we'll go ahead and hand this off to Mark Nelson. Mark.
Thank you very much, Stephen. As some of you may know, my name is Mark Nelson. I'm one of the senior staff consultants here at Employers Group. My background is practicing on the management side, labor and employment relations law, and I teach university courses on topics relevant to employee relations. I am out of our Employers Group regional office here in Washington, D.C. So those of you who are early risers, please know you can always call into the helpline from 5 a.m. on. Today's webinar, I do need to address some disclaimers before we get started today, just so that everyone knows where we're approaching this topic. A determination, as is the case with any webinar we conduct, a determination of the best course of action to take with any unemployment insurance action involves detailed inquiries beyond the scope of the general guidelines we'll be addressing today. So please, nothing in this presentation should be construed as rendering advice of any kind in any one particular case. I should also stress that this is not intended to be comprehensive. We certainly don't have enough time to go through the several pages relevant to voluntary leaving and discharges for misconduct as they are spelled out for us in the California regulations. However, we will be highlighting the most important points. Again, just to reiterate, please know that if you're contemplating a termination for a specific employee, please don't consider anything we're offering today to provide specific advice in that particular instance. Please know, as we talk about the regulations today, and we will be spending a little bit of time with the statutes and the regulations themselves, we're looking at those as more of a launching off point into discussions of considerations that you want to take into account when facing particular employee relations scenarios, understanding that what you do and what you say may impact any subsequent unemployment insurance action. So knowing exactly the standard that you might be held to down the road could inform how you conduct yourself now. So we're basically preparing you to prepare for the unemployment insurance in so many words. Finally, please know we are not going to go into the specific, you might be happy with this, but we are not going to go into the specifics of any base periods, alternate base periods, how to file the 1080EZ, the particulars of appeals processes, nor are we going to go into scenarios employers are more likely to win and the scenarios employees are more likely to win. Any of you have gone through the process know there are too many variables for any sort of reliable data on that, at least right now. Please, 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 if you're interested in any of that information, we will defer you to the DE 4527. Don't worry about writing that down. I have a link to it at the very end of this presentation, but it's the article on managing unemployment insurance costs published by the EDD. It's actually a very helpful resource. We also have additional helpful links at the end of this presentation for those of you who would like to kind of go back and take a greater look at the topics we'll be talking about today. I will warn you, with any of those links that I have at the end of this discussion, it will get a little dry. That being said, let me go on and kind of give you an overview of what we will be talking about with a little bit more specificity. We're going to start with the statutes and regulations themselves, just to introduce you to the language. Then we'll launch into misconduct scenarios. I'm going to spend the majority of my time on misconduct scenarios simply because that's more relevant for an employer scenario. Voluntary quit scenarios are where the employee leaves with good cause and is also eligible, but generally speaking, the employer must prove the misconduct scenarios while it's on the employee's shoulders with regard to the voluntary quit scenarios. So obviously, you guys, I'm sure, would like to know kind of the generalities of what you would be required to prove to allege that an employee was not entitled to unemployment insurance because of a misconduct termination. At the end, I will kind of pull back, and those of you who do not feel like you want to learn every term of art today, never fear. We will be keeping things on very general terms. Both at the bottom of every slide that we'll go through, I'll pull back and say, don't worry about what I just addressed. Here's kind of what you need to be thinking about. And then finally, at the very end, don't worry about all these additional considerations that we've just talked about. Here are some general operating principles, some rules of thumb, so to speak, for you to kind of always have in the back of your head when contemplating any termination, so you needn't have to remember all of the variables in each particular scenario. All right, with that, let's move on. On to the law itself, just to kind of familiarize you all with where we're coming from for the sake of the rest of the presentation. An individual is disqualified for unemployment compensation benefits if the director finds that he or she left his or her most recent work voluntarily without good cause, or that he or she has been, quote, discharged for misconduct connected with his or most recent work. What does this mean? Again, here I'm going to give you all the generalities at the bottom of each slide. In other words, employees qualify for unemployment insurance benefits if they were separated from work through no fault of their own. I'm sure we're all very familiar with the notion, or at least remotely familiar with the notion of employment at will, which is the legal standard that's presumed to drive all employment separations. In fact, in all states except Montana, employment at will is the presumed nature of the employment relationship, meaning you can separate an employment relationship, either the employer or the employee, for a good reason, a bad reason, or no reason at all, provided it's not an illegal reason. So you don't have to have notice or cause to let someone go. Obviously, you can negotiate those terms away in a collective bargaining agreement with a union, or individually with employment contracts that provide for different reasons to separate employment. But employment at will, essentially, you can leave at any time. And for any reason whatsoever. Obviously, this is a different standard to qualify for unemployment insurance. You're talking about a fault-based system where you look at whose fault is it for the job separation to qualify for unemployment. So already we have a tension between what is unemployment at will and what is the unemployment insurance code permitting for eligibility for unemployment. We would then focus today's discussion on the higher standard of whose fault is it, rather than you can let someone go for no reason at all. Moving on. Additionally, we have a presumption. In other words, an individual is presumed to be eligible for unemployment insurance unless the company has set forth facts sufficient to overcome that presumption. In other words, the presumption of eligibility for unemployment is rebuttable by an employer who has completed the forms. and submitted them to the EDD timely. Speaking of which, there was some recent legislation. Those of you who follow legislative developments in the employment sector know that there was the Federal Trade Adjustment Assistance Extension Act of 2011. Let me get to that slide. And part of that was the Unemployment Insurance Integrity Act, which basically required all states to impose new obligations on employer initial responses to unemployment insurance claims. California responded with AB 1845. You may have heard of that. In other words, what does all of this mean? Essentially, it means respond timely and thoroughly to the first notice that you receive from the EDD. If you don't believe the employee is eligible for benefits, respond. However, even if you've missed the 10 calendar day window, even the EDD says in the DE 4527, the Managing Unemployment Insurance Costs, that you should still file your response even if it's not timely. The administrative law judge may determine that you had good cause for being untimely. By the way, incidentally, a lot of our members have scenarios where a specific individual is responsible for receiving claims of unemployment and responding to the employer timely. Certainly, we've had situations where those folks have gone out on a leave of absence. The documents come in and sit on someone's desk for 6 months. Of course, that now is no longer timely. Always, always, always with any government document you receive from an agency like the EDD, have someone designated in their absence to receive that document for them. Moving on, by the way, for our intents and purposes as an employer, this language is probably more relevant for us. If ruled, or if it is ruled, after the employer has submitted the completed forms, like the DE 1080EZ, the claimant left the employer's employee voluntarily and without good cause. In other words, that's one of the scenarios. The employee has to prove that. Or left one of the under the following circumstances: benefits paid to the claimant subsequent to the termination shall not be charged to the account of the employer. The first one of those, of course, is if we discharge the employee for misconduct. I also have a few additional scenarios. Feel free to look at them at your leisure. Scenarios involving situations where you've got employees who were students and left to return back to school, or accompanied a spouse or domestic partner to a job in a new location, domestic violence abuse scenarios, those sorts of things we will not be talking about at great length today, but those would also be disqualifying reasons. Now, let me dive into the regulations themselves. So we have the law telling us what the language is: misconduct, discharge for misconduct, or voluntary quits for cause. Like I said, first we'll talk about those misconduct scenarios. Here are the regulations. You can actually Google them and look at greater length at them if you have a specific situation that you're contemplating. But I will be touching on the highlights, the more typical scenarios of these misconduct circumstances in just a moment. But please note, if those of you are less familiar with how to read a statutory citation, when you see these numbers and acronyms at the top, please note there's actually an easy way to understand them. When you see the numbers in front of like CCR, you're looking at the title. So that we have several titles of our regulations here in California. In fact, the U.S. Or the federal law has federal regulations as well. Those are called the Code of Federal Regulations, so it's CFR instead of CCR. We have California codes of regulations, but Title 22 is where we find the unemployment insurance regulations. So you see 22 CCR and then the section 1256. So, or if you want to look for any one of these regulations, just enter 22 CCR and then the number 1256-30 for general principles regarding misconduct. You can, just Google that and it'll come up, no problem. All right, I apologize, that was a quick aside. But moving on here, as you'll see, we go down in a few different scenarios. You're talking about misconduct terminations based on dishonesty, based on tardiness. Violations of employer rules are very typical scenarios. This is a little more difficult to read for those of you with the same size screen as I have. Again, please feel free to go back to this or return to this at your leisure. These are all the scenarios involving voluntary quits and what constitutes good cause for leaving your employer and qualifying for unemployment insurance. Again, we will kind of breeze through these sections relatively quickly because they are less relevant than the misconduct scenarios for most of our employers, but I did want to point them out to you. All right, let's move on generally then to misconduct scenarios. In legalese terms, this is what you're looking at when you're looking at qualifying, or not qualifying, I should say, disqualifying your employee from unemployment insurance by virtue of the fact that we let them go for misconduct, meaning they are no longer eligible for unemployment. The employee, we must establish that the employee owes a material duty to the employer and breached substantially that duty. That breach is willful or wanton disregard of a duty, and then finally that breach disregards employer's interest and injures or tends to injure the employer's interest. What does this mean? Don't worry about these terms of art. All we care about is that we are actually communicating a relatively high standard here. Words like willful or wanton convey a high standard for proving disqualification for benefits. This is not as easy as simply saying they were tardy to work one day. Moving on, kind of diving into these elements a little bit more in depth, we can see that there must be a causal relationship between the employee's acts of misconduct and the discharge from employment. Please note, what does that mean for you guys? Delays of longer than a few days imply that the act was not a direct cause of the discharge. What does that mean for how you administer your terminations? Please, please, please don't allow unnecessary delays in employment actions, from workplace investigations to the discharge itself. They actually cite an example in the regulations involving a scenario where a bookkeeper embezzled $250 from the employer to keep his son from going to jail. The employer discovered the embezzlement, but in view of the circumstances decided to give that employee another chance if that employee agreed to repay the money in weekly payments. 2 weeks later, the employer concluded that the probability was too high that the employee would embezzle again, and therefore changed his mind and fired the employee. In this particular circumstance, the EDD would consider that not to be discharged for misconduct because there was too much time that spanned, and the real reason was a revisitation, not the fact that the employer was firmly under the belief that the employee would embezzle again. So again, these sorts of hesitations, changing your mind, delaying investigations, or the termination itself allow the EDD to draw different conclusions than perhaps the one you wish to convey. Moving on. Isolated acts are generally not misconduct when there's mere inefficiency or unsatisfactory conduct or the failure to perform well because of an inability, distinguishable from an employee who can do the job, just elects not to. Ordinary negligence, meaning that they just simply forgot, for which the consequences were not great, or good faith errors in judgment. In other words, in these particular circumstances, just counsel your employees when they commit acts like these. Don't fire them. We're a big proponent of progressive discipline. And when I say progressive discipline, please note, I'm not talking about a formalized process where all first warnings are verbal, all second warnings are written. You always want to reserve the right to apply the appropriate level of discipline and keep the flexibility in any sort of progressive discipline. But the general notion of progressive discipline is a standard these days. So generally following progressive discipline is always the best, measuring the misconduct or the poor performance with the appropriate level of disciplinary response, i.e., in most cases in these scenarios, you'd be talking about a verbal unless it were repeated. Please note, they take the position that prior warnings are less necessary when the employee acted willfully or wantonly. In other words, again, getting back to that original language, that very high standard, and those acts caused severe injury. So in other words, if you're looking for a termination in the first instance for an employee who misbehaved, look for both factors to ensure you have some prior, or I should say, ensure that you have some prior discipline to fall back on to support the termination. We'll talk about what that is here in just a second. Again, the example that they provide for this sort of a scenario is a taxi driver who fell asleep while transporting passengers and became involved in an accident. Obviously, that was wanton misbehavior on his behalf, and of course, those acts can or tend to cause severe injury because the responsibilities that taxi driver had were so were so high in nature. It only makes sense that the employer should be able to take more severe action for that kind of misbehavior. All right. In scenarios involving ordinary negligence, like we talked about before, generally speaking, ordinary negligence is not misconduct sufficient to disqualify the employee from unemployment insurance, but that may be misconduct if there were previous warnings for similar negligence and the employee has the ability to perform satisfactorily. The regulations go out of their way to distinguish two scenarios. Incidences where an employee is able to perform but chooses not to is categorically different than a situation where an employee, through best efforts, is still unable to do the minimum requirements of the employer. In those latter circumstances where the employee can't perform despite best efforts, the burden is generally on the employer. In other words, you should have done a better job vetting your candidates for the position and determined that this individual was ineligible to do the job. But in situations where we know the employee can do that job, then ordinary negligence may rise to the level of misconduct. Please note, always counsel for poor performance and ask the employee to make suggestions regarding any training to ensure that the employee himself or herself agrees that they are able to perform at the minimum standards. In other words, I follow a disciplinary notion. It's the mnemonic FOSA, which stands for facts, objective, suggestions, and action in any disciplinary write-up, meaning facts, what exactly happened, not your conclusion about what happened, but the actual facts detailed as objectively as possible. Employee X was observed shouting, 3 employees complained, 10 employees turned their head around, whatever, and disrupted their work product. Then objective employees are not to raise their voice when in a call center environment or something along those lines. Then suggestions, what do we recommend that the employee do to bring their behavior within the company's requirements or objective? This is where you solicit the employee to ask the employee, what do you think you need to perform within expectations? And this is also where you can get agreement from the employee that they have the capacity to meet those objectives. And then finally, action, what will happen if you don't, which of course is important as well. Moving on. Absenteeism. Now we are moving past misconduct scenarios more generally into the specific scenarios that we'll be talking about the remainder of these misconduct scenarios. Absenteeism is often the basis for terminations, except for first-time unexcused absences due to good faith error. An absence may be misconduct if, and this is coming directly from the regulations, a reasonable person would not consider the absence to be for compelling reasons, and the employer has not condoned the absence. In other words, we have disciplined employees who do not call into work appropriately, and we don't let those things slide. Or alternatively, the employee has not notified the employer of the absence where notice would be feasible and no reason is present not to give that notice. So in other words, in these particular scenarios, the strongest case for discharge is when the employee could have notified but didn't. First-time short periods of absence generally are not misconduct, as we said, warning discharge, unless they're aggravated by facts imposing unusual duties on a particular case. In other words, everyone knew that the company was under a deadline that had significant consequences if that deadline was not met, and one person just decided not to show up. Despite it being a holiday. As we look forward to the 4th of July, I'm sure some of you may be familiar with scenarios like that. We certainly are on the helpline. Prior warnings for unexcused absences do not necessarily negate compelling reasons to be absent, but they are pertinent for non-compelling reasons. So in other words, in these particular situations, even those of you with point systems for your attendance, if you tell employees that they are not to be absent from work more than 10 instances or something along those lines, and the employee is on their 10th instance, but that 10th instance is for a reason that stems from their child being violently ill and having to take them to the hospital. Obviously, the employee, even though you have those prior warnings, the incident that caused the job separation was for a good reason, a compelling reason, and therefore the employee would qualify for unemployment insurance. In non-compelling reasons, of course, then those prior warnings can have more effect. Lack of prior warnings for non-compelling reasons may imply that the employer actually condones the behavior. So again, always, always, always discipline your employees if they fall short of your attendance policy. If you can wait until employee admits to no compelling reason, that's always better. Obviously, drawing lines in the sand is never a good thing either. I would never give someone a last and final warning and then give them another last and final warning and then give them another last and final warning after that, waiting for the opportune moment to let them go. In situations involving duty to employer, in other words, now we're moving past absenteeism onto duty to employer. All employees have a common law duty of loyalty and duty of care to their employer. An employee's willful disregard of the employer's interest is generally not misconduct in the first instance, though continued acts or statements may be misconduct. Some examples that some standards that they provide for what may constitute misconduct would be if they disparage their supervisor, employer, or product, or incite coworkers to damage property, or assist in the employer's competition. I would hope so in those particular instances, obviously. In other words, in these particular scenarios, don't discharge, simply discipline unless the employee's actions are in fact severe. What's severe? The example that they provide in the regulations would be when an employee argued at work with a co-employee about a work assignment, the employer reprimanded the employee who responded to that particular employer representative, management representative. If you would have been around, there wouldn't have been any trouble anyway. The remark was not smart. It was not made in the presence of others, but in this particular instance, the EDD determined that that was not misconduct warranting discharge. So in that particular scenario, had it probably been in front of other employees, I might have argued that it would have been misconduct. But the example that they provide to kind of flesh this out a little bit more, they concluded in that particular instance, because the damage was minimal, that would have been better left with a warning as opposed to discharge. What about dishonesty? False claims are misconduct when willfully made by the employee and relate to the records, coworkers, or employer, and, in other words, these are not ors, but willfully made and relate to the company and substantially injure or tend to injure the employer, or are substantial violations of the duty to the employer. In other words, the consequences of the lie must be substantial to warrant misconduct. Employees who lie about inconsequential acts generally don't disqualify from unemployment insurance. In these particular circumstances, if the example that they provide here is when an employee observed a co-worker stealing a stack of paper money from the employer's cash till. The employee did nothing about it, so the company fired that particular employee. That would have been misconduct, obviously, because by virtue of the employee not coming forward and disclosing, that was tantamount to an act of dishonesty themselves. Moving on, but staying with dishonesty, false statements are willful, to provide a little bit more clarity of what they deem to be willful, if made in the employee's full knowledge of the falsity, or the employee doesn't believe the statement is true, or made when the employee doesn't care about its truth. In other words, aim for getting the employee to admit to dishonesty or ensure the lie is obvious on its face when you're investigating the act. Obviously, again, with any job separation, you always thoroughly investigate and get the employee side of the story. In these particular instances, it's best if the employee, if you can get an admission out of the employee that, in fact, they understood it to be a dishonest act. Insubordination is another hot topic when it comes to unemployment insurance benefits. Insubordination is deemed under the UI code to be misconduct if the employee intentionally disregards the employer's interest and willfully violates the standard of behavior by refusing without justification to comply with the lawful reasonable order of the employer, or committing an act which exceeds authority either expressly granted or impliedly created by a failure of the employer to object otherwise. In other words, in these particular instances, when you're dealing with an employee who refuses a work order, be sure you tell them that you interpret their actions to constitute insubordination. I happen to think that, or it's commonly the case, at least in labor relations scenarios involving unions, that insubordination is kind of the industrial capital punishment, meaning that's the get out of jail free card for employers who term employees in their first instance. In these particular regards, unemployment insurance code, the standard is just a little higher, so you want to go these extra steps. But in doing this analysis, insubordination is not misconduct if compliance is impossible, it would impose unreasonable burdens, doesn't relate to or affect the employer's interests, the employee believes the compliance would violate the law, and the employer doesn't explain that away. Important point here, if an employee says, I can't do that, that's against the law, this is where you step back and convince the employee, train them, better yet, at the beginning that this is not a violation, but you need to clarify that it is in fact not a violation of the law before taking action. And the employee believes there's a risk of injury or illness, so again, dispel the employee's fears of injury or illness, and then finally, the employee doubts the authority of whoever issued the order. In those particular instances, be very careful before taking action. You need to put yourself in the shoes of the employee and understand why they're refusing, and if you can conclude that the employee has no basis to do so, then of course you're moving towards the direction of that being insubordination. Misconduct is not insubordination if the act is incidental, accompanies or is reasonably necessary to accomplish an authorized duty. The employee believes the act was necessary to prevent substantial loss and impractical to express it, or the employee makes a good faith error in judgment. Again, with these scenarios, as in the insubordination case, dispel the employee's beliefs. What about manner of work? Manner of work being this isn't the same as employees who have the ability to perform the work. Rather, they can do the work, but they consciously choose not to follow the manner of work that the employer imposes on them. So if it's willful and substantial disregard of an employer's interest, the acts are misconduct if they are intentional, knowing, or deliberate. Again, high standard here, grossly negligent, or repeatedly performs negligently after prior warning. You'll see the theme here. Intentional or grossly negligent acts in the first instance tend to be easier for you to prove as misconduct than regular or ordinary negligence, where just slip the employee's mind, in which case discipline, don't discharge unless it's subsequent. In staying with manner of work, intentional, knowing, or deliberate failures to perform are categorized as follows: quality, of work performance is misconduct, quantity, or in some cases discourtesy to the public. In those particular instances, when we're talking about examples that illustrate that, deliberate inefficiency in the quality would be where an employee, in this is drawing back to the regulations, the employee being a precision assembler who was discharged from employment for the first 3 years of that employment. The employee had been performing satisfactorily, but then the work deteriorated. The employee had no excuses to the employer for the poor work other than the fact that the employee could not see the work, but refused to consult with an optometrist because they did not want to wear corrective lenses. The employer discharged the employee, and that was for misconduct. In terms of, it was essentially the employee was deliberately diminishing the quality of their work by virtue of the fact that they did not. They refused the accommodation that the employer invited. What about deliberate inefficiency? Deliberate quality of work, I should say. The example that they give there is a salesperson who is expected to call on old customers, develop new customers, and submit weekly reports. The employer had reprimanded for poor performance. The salesperson agreed that they should call on at least 30 customers each week, yet without excuse, 5 weeks in, only made 14 calls in a week, 19 in another, and 12 in the third, and failed to file 3 weekly reports. The employer discharged that person. That was, again, misconduct due to an inexcusable failure to meet the quantity standards. Discourtesy to the public, I think, goes without saying, so I won't go into what that example would be. Again, moving on with manner of work. Gross negligence can be misconduct as well. In that particular scenario, the one we would probably posit is, again, in the regulations. As an example there, as a captain for a large airline, the employee was in charge of a plane with 29 passengers and 5 crew members. The first officer was piloting the plane. As it approached the landing, the captain pilot with the captain pilot under the flight rules responsible to carry out the first officer's orders. The first officer ordered to gear down for landing, but the employee failed to put the gear in full operating position and check the performance in accordance with standard operating procedures. The employee thought the gear was down. The plane landed with wheels up, resulting in about $250,000 of damage, but no injury to passengers or crew. Obviously, that was gross negligence. That example was so extreme, it was a little disconcerting for me to read. I don't know about any of you. Repeated acts of ordinary negligence can also be misconduct if the employee has the ability but shows substantial disregard based on the number of negligent acts, the span of time, the seriousness of each incident, and similarity of instances. In other words, discipline even well-intentioned negligence. Don't let the nice employee go without a write-up. We often see that. The manager does not like to be the hammer and will not discipline when ordinary acts of negligence occur. But in these particular instances, that's giving the employee license to engage in additional negligence before you can really do anything about it. Let's see here, moving on. Good faith errors in judgment don't count if the employee exercised reasonable diligence and did not knowingly act in a manner prejudicial to the employer. Shore up ambiguities in these particular duties and priorities that you consider to be relevant. In other words, there should be no unauthorized, or I should say in the example of no unauthorized overtime versus never abandon your post until relieved of duty. For example, a security guard at a kiosk is told 2 competing rules. Never work unauthorized overtime, but never abandon your post until someone relieves you of duty. If the replacement is late and the employee is going to incur overtime, obviously there are competing priorities here. So make sure that employees understand what's going on here. In that particular instance, the EDD sided with the employee who left the post thinking they weren't allowed unauthorized overtime, and that was the more important consideration. What to do when dealings with other employees cause a termination. That may constitute misconduct when employees provoke or are the aggressors. address coworkers in vulgar, profane, abusive language, or engage in dishonest conduct like stealing from other coworkers. Conduct, as always would be the case, thorough workplace investigations and ensure that witnesses are questioned. With regard to other employees and dealing with them with prior warnings, it can also be misconduct when they continue to annoy or bicker with or engage in horseplay with coworkers. So again, in these particular instances, there's two different standards. The prior slide, we saw what they would consider to warrant termination in the first instance. With these instances, where it's the consequences less severe, discipline, don't discharge in those scenarios. Don't think management's responsibilities end when mediating conflict. Be sure to discipline when it's relevant. In other words, if you get employees to shake hands at the end of a fight, that's not where it ends. You need to still write them up. What about tardiness? Tardiness, again, like absenteeism, may rise to the level of misconduct if it's repeated, unexcused tardinesses in conjunction with other violations, and disciplinary action was given in those prior violations. And then, of course, single incidences only when they can reasonably foresee that there's substantial injury if they show up late and the entire production is shut down because this employee who's critical to it shows up 3 hours late or 4 hours late. Again, make clear the consequences of poor attendance practices. Tardiness is not misconduct when it's occasional isolated lapses without prior discipline, compelling reasons. Always counsel for tardiness, no, but again, like we talked about with the absenteeism, know that the compelling reason may trump your write-up. As is always the case, if you can wait till the employee admits to no compelling reason, though again, like we talked about earlier, don't draw lines in the sand. Sometimes losing an employment is more important than allowing employees to think that the employer will never enforce its attendance practices. Violations of work rules are misconduct. If the work rule is reasonable, the employee knew it, and the violation of the work rule is willful, material, and substantially injures or tends to injure the employer. Again, we're getting back to, just like with misconduct generally, this is a very high standard. You're not talking about inconsequential rule violations. You're talking about major scenarios. Like I said just now, a violation of a minor work rule is generally not, but can be misconduct if there's prior discipline, the violation substantially injures, and the employee's course of conduct demonstrates. For minor work rules, discipline in the first instance, don't discharge. Off-the-job violations are not misconduct unless the employee uses the information obtained at work to carry out the crime or other violation, or there is any other substantial connection with the work. On-the-job violations are misconduct for violations of law when minor in nature and no prior, unless I should say minor in nature and no prior warnings, or the employer ordered, participated, or condoned the act. In situations where a manager tells an employee to do an illegal act, then obviously the employer is not going to succeed at a misconduct termination. The risk of negligent retention may sometimes supersede unemployment insurance concerns, and when you have those scenarios, consult your counsel. In other words, keeping an employee who the company knows to be a danger to coworkers or customers or the company at large, that might trump any decision to hold off until we can terminate them for some other reason. Voluntary quit scenarios, just generally, again, like I said, I will breeze through this section because as a general rule, it's on the employer, on the employee to prove these scenarios, but good cause to quit exists when there's a substantial motivating factor causing the employee to quit that is real, substantial, and compelling, and would cause a reasonable person who is still desirous of employment to leave under the same circumstances. Again, that itself is also a very high standard to prove. It must be timely in connection between the employee leaving and the reason for leaving. So in these particular scenarios where there's a gap in time, like we talked about with misconduct, and the employee cites a reason that happened months ago, that doesn't make them as credible. In these particular scenarios with voluntary quits, and you should do it anyway, always conduct exit interviews when possible and ask questions that invite the employee to make disclosures as to why they're leaving. Employee has a duty to preserve employment, which can be satisfied by doing any of the following: allowing an employer to remedy the problem, seeking leave or a transfer, or taking steps within their own control. In these particular scenarios, what we recommend employers do in all cases is always have an open door policy where you invite employees to bring complaints, not just to one isolated individual if that person is unapproachable, or if it's a gender-based complaint, preferably have someone of both genders, and then an option for that person to essentially bring the complaints to a number of individuals, ideally someone at some level of management and above, so that the options are multiplied and all of those individuals know what to do when the complaint comes to their attention and to pursue it and make sure that it's remedied. Quitting for school is not good cause unless, in these scenarios, again, I won't go into great depth with them, but keep in mind also, as we learned about in the law itself when citing it at the beginning, when employees return to school for short work periods, then that's not even on the employer anyway. Discipline, an employer has a right to reasonable discipline, which is nice, of course, reassuring for us as employers, if it's work-connected and reasonable when measured against custom practices or similar industries. Again, this gets back to the notion that progressive discipline really is kind of the standard. We understand, or we generally operate under this framework that negligent acts in the first instance are usually a verbal. Fighting can be a termination in the first instance. Repeated acts, written warnings. Those sorts of standards kind of weave their way into the unemployment insurance regulations as well. Voluntary quits when it comes to discipline. Discipline is good cause for quitting. In other words, an employee would be able to quit and still collect unemployment when the discipline is not work-related or detrimental to the employer, violated a rule for which the employee had no actual or constructive knowledge that the rule even existed, excessive or unreasonable, violated the employee's constitutional guarantees, refused unreasonable burdens, or refusing to break the law, imposed undue risk of injury or illness, patterns of hostility or abuse towards the employee by the employer or supervisor, the employer demanded reimbursement for shortages, breakage, etc., or wasn't timely after the employee's act or omission. In other words, we delayed our investigation and our disciplinary response. In these particular instances, again, thoroughly investigate before disciplining employees and always dispel any employee misunderstandings. I would also go so far as to say that, manage your managers. Managers who abuse or bully their staff can create these voluntary quit scenarios, entitling the employer to benefit. And obviously, I'm talking about concerns that are even greater than unemployment insurance. You don't want a manager working for you who bullies employees, but certainly just because somebody is more difficult to work with is not necessarily something the employer can turn its back to without a bottom line thinking when it comes to unemployment insurance. All right. Voluntary quits when it comes to transportation. An employee may be able to quit and still allege good cause for doing so when there are substantial changes to the work location, hours, or if there are health problems associated or the employee has to move for compelling reasons and neither the private nor public transportation is available, and the employee explored reasonable alternatives like carpools. So not just the public transit, but other measures were exhausted as well. Under those circumstances, consider the consequences for employees before you change their schedule. Folks who float between shifts, that can create its own problems. Changing schedules, locations, moving individuals between departments, that sort of a thing, and those departments are located at entirely different campuses. Those all can have unemployment insurance considerations as well. When it comes to domestic issues for employees, they quit for good cause if they have obligations that are real, substantial, and of a compelling nature, causing a reasonable person, again, desirous of employment, to quit due to legal or moral obligations for health care, welfare of that employee's family, or parents exercise control over minor employees, or existing or prospective marital status of employees compel them to have to quit to relocate with their spouse. In other words, work with your employees who have genuine crises in their personal lives. I'll touch on this again at the end, but you always, always, always want to be cognizant of those life events that happen for employees and the need to care for loved ones when the emergency happens and the employee needs to respond. But again, I'll talk about that in just a moment. When it comes to family, compelling reasons to quit include when the family member is seriously ill or disabled, relocation, death, elderly family care, child care, and finally, family unity. Quick note here, it's always best to have bereavement leave policies and accommodate accordingly for those employees who are having a difficult time with the passing of a loved one. And certainly bereavement policies are very effective in allowing individuals a short period of time in which to be with family. Quitting for good cause with marriage includes relocation scenarios or accompanying a spouse to another location. Well, that's actually accompanying, I read that as the same, I guess, perhaps. Remember that employers are not responsible in these scenarios, like we talked about at the beginning. That's one of the excuses that's permitted under the Unemployment Insurance Code. When it comes to experience, if an individual is quitting because the highest skills that they possess are not being utilized, it's not good cause unless they are reassigned after hire. If the employee is quitting because insufficient experience or training, again, not good cause. If they're quitting because of the lack of opportunities for experience or training as well, that is not good cause. Conduct exit interviews when you're dealing with these scenarios and ask questions that invite employees to make disclosures about why they're leaving and what their basis is, so you can kind of challenge their credibility later when they try and change their story before the administrative law judge. Conduct routine health and safety inspections. In these particular scenarios, I'm now moving on to voluntary quits with safety. Those are key things to take into account. Retain the services of an industrial hygienist if necessary, especially if you work in a production environment. You want to make sure that employees don't have arguments, that the company is providing an unsafe workspace for their employees. When employees voluntarily quit for cause for personal reasons, that good cause is only present if a reasonable person desirous of employment would have left the work and could not have been excuse me, the way it's worded is awkwardly for me to read. I apologize, but could not have been handled with leave because of financial difficulties, legal and business affairs related, rest or vacation homes, return to former homes, or finally self-advancement or self-employment. Work with employee hardships. When they're going through substantial financial or legal difficulties, in these particular circumstances, it's always best to grant something like a personal leave of absence. And then, of course, if they can't come back after that, then you're looking at a better case for the employer. When it comes to time, good cause can exist for quitting and then drawing unemployment if there is a real, substantial, compelling reason for quitting for unreasonable demands on the employee's time, and the employee inform the employer of the reasons for leaving and allow the employer an opportunity to adjust the situation. Again, work with your employees in the short term if they can't work outside their schedule. You know, in California, we know you can have mandatory overtime. The one consideration we would have is that if you don't have a history of doing it but suddenly require mandatory overtime, if individuals have compelling reasons, family care, school, care for elderly family members, those scenarios, work with them in the short term until they can find appropriate care for those individuals. Voluntary quit scenarios involving wages. Good cause to quit exists only if the following: an individual is paid less than the state or federal minimum wage. Of course, if you're doing that, then we have bigger problems. If the employer does not pay wages when they are due, again, if this is happening, we've got bigger problems. The employee is transferred to unsuitable employment after being hired on for a particular job. or the employer breaches an agreement, or finally, the employer misrepresents the duties, hours, etc. Be sure, all of you, provide the wage theft prevention notices, that 2810.5, the Labor Code section 2810.5, that you give to all your non-exempt employees, and be sure exempt employees know what their salary is. It's no good cause to quit if the following: the employee knew of the wages but later decides it's not enough, doesn't pay or doesn't want to pay for incidental expenses, the employer deducts for shortages based on the employee's culpable negligence or willful misconduct. By the way, for you to deduct when an employee is responsible for a loss to the company, know that the standard requires as much. You can't just do that for acts of ordinary negligence. The employee has to, or that action must rise to the level of gross negligence or willful conduct. The employer denies the employee's request for a raise. Just because the employee thought they were ready for a raise and didn't get it does not mean that that's voluntary quit for cause. The employer refuses advances on wages, which you're not required to do and we don't recommend doing ever. And then finally, on commissions and paid not substantially less than prevailing wage rate for the locality. I think these go without saying, so I won't go into depth, obviously, in terms of trying to summarize them. When conditions cause an employee to quit, that can be good cause if the employer causes undue hardship, discriminates, or is unreasonable under the circumstances. Again, we're talking about scenarios that probably have more legal consequences for employers than simply unemployment insurance eligibility. You're talking about Title VII actions or Fair Employment and Housing Act violations there. So certainly under these, again, they go without saying. Ensure you have an EEO and harassment policy in place and that you follow it to the letter, and that employees are trained in who to approach with regard to alleged harassment, or if they're witnesses to harassment, that sort of a thing. Additionally, with conditions, the refusal to follow a rule is not good cause unless it is only applied to one employee, causes undue hardship, or is unreasonable, defined as any one of the following. These are all logical scenarios, so I won't go into too much here. One important point to make very clear: when you're talking to your employees, rules don't matter to employees, and for that matter, the EDD, unless there's a logic behind them. You don't just implement rules because you can. You implement rules because there's some reason that they are in effect. And obviously, the logic underlying those rules generally is critical to employees understanding why they're doing why they're being told to do what they're being told to do. Conditions: quitting to object to the method, manner, or quality or quantity is not good cause unless it reduces the employee's earning power, like a scenario involving an employee who's responsible for or gets paid based on the number of widgets they produce, but the method in which they're producing those widgets is not effective, so they know that they're not earning as much as they could. The methods are inferior. The employee will lose skills. In other words, the employee came in with a high level of skills, but were requiring the employee to work so quickly that they can't work efficiently and operate at the best of their abilities. Substantial increases in the quantity with no wage increase can be the basis for voluntary quit with cause. Be prepared to defend the method and manner if the employee asserts this. In other words, make sure that you do have the best methods and manner when it comes to these particular scenarios. Transfers to a reasonably related work and compensation is not good cause unless the work is unrelated, would cause the employee to lose proficiency, would not cause a substantial reduction, etc. Again, these go without saying. Now, moving on to the conclusion, which I will knock out here in the next 2-3 minutes. Always, always, always ask yourself whether you would characterize your employer as a good guy or the bad guy in any narrative resulting in job separation. I'm sure a few of you on the line have heard me tell this story, so please, I beg your patience while I tell the remainder of you. When I was in law school, my employment law professor did not start class discussions like everyone else in my contracts law classes, property law, corporations, etc. In my employment law class, rather than having Mr. Nelson stand and respond to the employer's questions by stating the facts of the case, the holding, the plaintiff's arguments, the defendant's arguments, etc., the employment law, a brilliant woman, said, everyone, I want you to take a vote. Who was a good guy and who was a bad guy? Inevitably, the good guy was the prevailing party in that particular case, and of course, that provides us quite guidance when it comes to how we respond generally. You don't need to know all the particulars of the facts that I just talked about to know who is the good guy and who is the bad guy under the circumstances. All you have to do is be able to abstract yourself enough from the particulars of these employees and what they've done to know, are we really able to play that good guy card in this particular scenario? And if so, then that's one step in your favor. You might also want to ask, was the employee treated as you would expect your mother, father, sister, brother, son, or daughter to be treated? Simply the fact that you don't have a bereavement leave policy and this employee lost their spouse and you didn't grant them any time whatsoever to grieve their spouse, is that how you would want your mother, father, sister, brother, son, daughter, or spouse for that matter to be treated? I would implore you to say probably no in those circumstances. In addition, fact finders don't like to be reminded that employment at will is the law of the land. In other words, judges and juries themselves may be subject to the, well, less judges, but juries are themselves subject to employment at will situations where they can be terminated for a good reason, a bad reason, or no reason at all, with or without notice or cause, the only thing being an illegal reason. And most of them themselves enjoy little job security. When you remind them that their employment status is as fragile as it is, that's not a great scenario. That comes directly from my employer as well. Given the cost of hiring employees, it makes no sense. It makes absolutely no sense that an employer would invest all that money, what is it, upwards of $30,000 now, on average per employee, just to turn around and fire them for no reason. Finder to sort out what that real underlying reason is. Sometimes, by the way, when it comes to all of this, and you need to keep perspective when terminating employees, sometimes unemployment is not the big concern. It may, in fact, be the least of an employer's worries. Work with your legal counsel to determine if losing the battle means winning the war. In other words, if you have a charge of unemployment discrimination that you anticipate coming down the pike, and you're worried about zealously defending unemployment insurance, it may be better for you not to have to appeal a decision and provide testimony under oath that can be used to challenge your credibility later. You and your counsel, legal counsel, may decide that that is not your primary concern, making an appearance at the unemployment insurance hearing. But that, again, that is a decision you should make informed with dialogue that you've opened or started with your counsel, your legal counsel. All right. With that, I will close out our conversation in earnest with helpful links. I mentioned at the beginning the Managing Unemployment Insurance Costs brochure published by the EDD. You can link to it with this particular link. We also have an online benefit determination guide that provides a little bit more detail. The California Code of Regulations are also located at this, so like I said, if you have a particular fact pattern, go up to that slide and click on 22 CCR, section 12, whatever, and you can actually pull up that link in Google Direct. Thank you for your time this morning. I know you're all probably thinking ahead to the 4th of July, so we really appreciate that you would tune in to us today. Have a wonderful 4th.